Good afternoon and welcome back. Now we'll begin today's last session, session number 4. And the topic of the session is Incidental and Special Proceedings in ICLS. And Professor Keungwan Lee from Seoul National University will moderate this session. Professor Lee, good afternoon.
Good afternoon. Good afternoon, ladies and gentlemen. Welcome to session 4 of this conference, the titled Law of the Sea for the Next Generation. In this session, we'll deal with incidental and special proceedings in ICLS. Well, I'm teaching public international law at Seoul National University, and let me begin this session by expressing my sincere thanks to the co-organizers of this conference. So the Foreign Ministry of Korea and ICLS and the Korean Society of International Law. Well, before discharging the pleasant duty of introducing our excellent panel, let me just say a few things about the UNCLOS and Korea. Well, as we all know, UNCLOS was adopted 40 years ago and opened for signature 40 years ago. And, well, I don't know whether you can see this or not, but this is a photocopy of a newspaper which was published, Korean newspaper, published on December 11th, 1982. So one day after this landmark convention was opened for signature and at Montego Bay. And as you can see, I indicated the relevant part in red. There was such a small news coverage, right? And which was composed of just 3 sentences. And well, fast forward to 2022. Well, the interest in the law of the sea and UNCLOS is so great in Korea that now we have such an important and conference here. So, and in the audience, you can find quite a number of the law of the sea, Korean law of the sea specialists, including young and bright students who are conducting their research in this field. Well, then let me introduce our excellent panel to you. Well, you can find more detailed biographical information from our booklet here. We have 2 speakers. Our first speaker is Dr. James DEVANEY, who is teaching at the University of Glasgow. And so he is an expert, especially in the dispute settlement, international dispute settlement. And his book entitled Fact-Finding Before the International Court of Justice was published in 2016 and is highly regarded by his colleagues in this field. And our second speaker is Judge Leinzat from ICLS. And she will talk on the subject of prompt release procedure so far. And Professor DEVANEY, he will address the question of provisional measures of the ICLS. And Dr. Elizabeth Leinzat is a judge at the ICLS since 2017 and is a member of the Seabed Dispute Chamber. And she's a member of the PCA, Permanent Court of Arbitration. And she worked as she was a principal legal advisor on public international law at the Dutch Ministry of Foreign Affairs and head of its international law department, well, from 2016 until 2017. Well, and then we have 2 discussants, and our first discussant is joining us online from Hamburg, and Dr. Ximena Henriks, and she is currently serving. She is currently holds the position of registrar of the ICLS, and she received her doctoral degree from the University of Hamburg in 1996. And our second discussant is Mr. Andrew Lowenstein, which is sitting here with us. And Andrew Lowenstein is a partner with the International Litigation and Arbitration Department of Foley Hogg, where he represents states before the International Tribunal for the Law of the Sea and other international judicial organs. And as you know, he is one of the most active litigators before ICLS and other international judicial organs. So we are very fortunate to have such an excellent panel. And so without further ado, let me invite Professor DEVANEY, James, to make his presentation. The floor is yours.
Thank you very much, Professor Lee. Thank you very much, of course, to the organizers for their absolutely tremendous hospitality so far. I'm absolutely delighted to be here with you this afternoon to speak specifically about provisional measures before ICLS. And I'm going to try to stick to the brief that I was given, which is to speak about effectiveness of UNCLOS, and specifically how we can measure the effectiveness of provisional measures under UNCLOS in practice and how it may be improved in the future. I'll do so by, first of all, laying out the general UNCLOS regime for provisional measures, taking care to point out some notable features, before, secondly, moving on to try to assess the effectiveness of provisional measures against relevant goals, and then finally look into the future to ask, can provisional measures be used more effectively? I'll try to do those three things in the next 30 minutes or so. So first of all, the provisional measures regime under UNCLOS itself. Of course, I think everyone knows that provisional or interim measures are a common feature of domestic and international adjudication. And in both domestic and international law, they have common functions which include the preservation of the rights of the parties, pendente lite, maintenance of the integrity of the judicial process itself, and or the prevention or aggravation of the dispute. These provisional measures are so common and have such common features, and in fact have been described as being an inherent power of international courts and tribunals due to the importance that they have for the proper administration of justice. In the particular context in which we are interested, they are set out in Article 290 of UNCLOS and Articles 89 to 95 of the rules. So Article 290 UNCLOS is quite a meaty article itself. You can see here some of the relevant provisions of it. I have highlighted and picked out some particularly relevant lines, and I'm going to take some time to run through these with you in the first part of the presentation. Now, the provisional measures regime under UNCLOS, like the majority of all procedural provisions under UNCLOS, is inspired by that of the International Court of Justice statute. You see the less meaty version, the equivalent from the ICJ statute, Article 41, on the screen at the moment. However, there are some very notable differences between the provisions in the ICJ statute and under UNCLOS. The first of these relates to bindingness. So Article 41 of the court's statute uses the term indicate, which led to some uncertainty over the binding nature of the ICJ's provisional measures for some decades, in fact, until the court clarified this in the Legrand case in 2001. In contrast, the binding nature of provisional measures under UNCLOS was made clear from the very beginning and is reflected in the wording of shall comply. This provision, when it was adopted, was groundbreaking, but I think it's safe to say that today this is now the standard approach for provisional measures before international courts and tribunals. The second noticeable difference between the ICJ and the UNCLOS regimes for provisional measures relates to the initiative. Well, the ICJ has the power to prescribe provisional measures proprio motu in accordance with its rules. ICLOS can only do so at the request of the parties. And we can see this from Article 290, paragraph 3, which states only at the request of a party to the dispute. And the third and final notable difference relates to the scope. This is a point that I will come back to later in the presentation. The scope of the measures that ICLOS can potentially order is much broader than the equivalent before the International Court of Justice. Okay, mentioning just a few more pertinent features in this first part of the presentation. Of course, provisional measures in this context are incidental in nature. That's the title of our panel. They can only be made when an application is made on the merits. Article 291 states if a dispute has been duly submitted, making this point clear. It's also a power which is discretionary, right? Article 290 refers to may indicate provisional measures here. And so ICLOS is not compelled to do so. In terms of procedure and practice, ICLOS has followed the ICJ in dealing with provisional measures through orders rather than judgments. What's the significance of this? Namely that we have a request for provisional measures by one party, then simply observations from the other party. A shorter procedure than it would be if it were dealt with through judgments. And finally, in terms of pertinent features, under Article 89.3, requests must, and this gives some guidance to parties requesting provisional measures, specify the measures requested, the reasons therefore, and the possible consequences, if it is not granted, for the preservation of the respective rights of the parties or for the prevention of serious harm to the marine environment. Finally, requests for provisional measures have priority over all other proceedings, except for prompt release proceedings, which have the same level of urgency. And it may also be worth noting that ICLOS may prescribe measures different in whole or in part from those requested by the parties. So, as a result, the scope of the power to order provisional measures is interpreted broadly, and this, Treves has suggested, may be to compensate for the inability of ICLOS to order provisional measures proprio motu. Okay, what about requirements for provisional measures then? There are three, and I will run through each in order. So first of all, Article 290, paragraph 1 states which considers that prima facie it has jurisdiction. And prima facie jurisdiction, being the first requirement, is assessed on the basis of whether provisions cited by the claiming state, quote, appear to afford the basis on which the jurisdiction of the tribunal might be founded. This is wording borrowed from the ICJ, from the fisheries jurisdiction case. And may also be worth pointing out here that before ICLOS, in contrast to the ICJ, focus of discussion has actually most often been on the provisions invoked by the respondent party to exclude jurisdiction rather than on the rights mentioned by the claimant state. Moving to the second requirement then, that of urgency. This is made explicit under UNCLOS. Urgency of the situation so requires. Not mentioned in the first paragraph, we should note, but it is included in Article 295, which relates to requests for provisional measures made by ICLOS before they later are dealt with by another international court and tribunal, such as Annex 7 arbitration. Nevertheless, I think urgency is considered an inherent part of requests for provisional measures. although, so for example, as the special chamber in Enrica Lexi said, the arbitral tribunal is mindful of the international jurisprudence developed by courts and tribunals on this question, which supports the view that urgency is an important element to considering a request for provisional measures. The third and final requirement for provisional measures before UNCLOS relates to so-called plausibility and link tests. And this is a more recent addition where ICLS has added these further requirements. Although we should note, in fact, that in Enrica Lexi, the Annex 7 tribunal didn't refer to plausibility of the claims. ICLS appears to be showing more restraint in recent years than the ICJ in terms of the link that ICLS requires between the measures requested and the rights claimed. And the ICJ has a more stringent, the ICLS is a more stringent standard than the ICJ's standard of a mere sufficient connection. We can see this from the 3 Ukrainian naval vessels and Padre Pio cases, which it's been said that provisional measures can only be prescribed when necessary to preserve the rights claimed, a more stringent standard than sufficient connection. Okay, moving to think then about the scope of the interest that can be protected through provisional measures. Article 290, paragraph 1, again, looking at the wording here, states that provisional measures can be made to preserve the respective rights of the parties to the dispute or to prevent serious harm to the marine environment. So 2 broad purposes of provisional measures under this article. The second of these is particular to ICLS and remarkable in and of itself. Measures for the protection of the marine environment in basic terms are not restricted to those that preserve the rights of the parties, and that is very significant. Why might that be? Well, UNCLOS, of course, contains a general obligation on state parties to protect and preserve the marine environment in Article 192, and it has been suggested that perhaps the ability of ICLS to prescribe provisional measures relating to the protection of the marine environment may come as a result of the very broadly worded nature of Article 192, which contains no explicit rights holder. In fact, Streves has gone so far to point out that parties to a dispute may act as defenders of the environment even when they have no direct interest involved. And I think that's a very interesting point to which I will return in the third part of this talk. Before moving on, it is also worth noting that it's serious harm that is mentioned here in Article 291, and that this is a less strict standard than that which is applied before the International Court of Justice of a risk of irreparable harm. Turning to Article 295, this states that ICLS can make provisional measures pending the constitution of an arbitral tribunal to which a dispute has been submitted. Now, why would ICLS make provisional measures when this case would end up before an Annex 7 tribunal? I think the rationale for that is clear. ICLS is a standing tribunal ready to act. Here, there are 2 requirements for the order of provisional measures: prima facie jurisdiction and urgency. Maybe it's worth also pointing out that the provision of provisional measures by one international court or tribunal on behalf of another is an almost unique situation in international law. And furthermore, that the requirement of urgency is stricter under Article 290, paragraph 5. So, for example, if an argument could be made that measures could wait to be made by the arbitral tribunal, then the urgency requirement under Article 295 will not be met. And finally, once constituted under Article 295, the arbitral tribunal may modify, revoke, or affirm provisional measures, as in fact happened in the southern bluefin tuna case, when once the arbitral tribunal was established, it found that it in fact did not have jurisdiction and revoked the provisional measures from the date of the arbitral award. I would also like to highlight an interesting point about implementation of provisional measures, simply because implementation of judgments or orders is not traditionally within the remit of international courts and tribunals, a point I think which came up a number of times in the previous panel. Nevertheless, under Article 95.1 of the rules, each party is under an obligation to inform the tribunal as soon as possible as to its compliance with provisional measures, and each party shall submit an initial report upon the steps it has taken or proposes to take in order to ensure compliance. And furthermore, under Article 95.2 of its rules, ICLS has the power to request further information from the parties. ICLS can have the president of the tribunal take follow-up measures, and we can see this in the Mox plant case. And in fact, reporting on provisional measures is something which has become, according to Tomka and Hernandez, a matter of routine. I think something which is an interesting point for those who take a comparative look at other international courts and tribunals. Similarly, that in the Arctic Sunrise case, as was mentioned in another panel, ICLS found that Russia had failed to comply with its reporting requirements. Okay, so much for the regime itself. Let's think about how we can assess the effectiveness of provisional measures. And before we do so, maybe a brief word on effectiveness itself. So provisional measures have been requested in 11 out of 16 disputes where possible, and at least some of the measures requested have been granted in 10 of these 11. How do we measure effectiveness? Well, if we use Yuval Cheney's goals-based approach, effectiveness compares outcomes against both explicit and implicit goals of judicial bodies once costs, externalities are also factored in. So what goals might provisional measures seek to achieve in the context of ICLS? I would suggest that there are 4: preservation of the rights of the parties, pendente lite, maintenance of the integrity of the judicial process, prevention of the aggravation of the dispute, and again, uniquely, the protection of the marine environment. So in assessing the effectiveness of provisional measures in this context, I will look at each of these in turn, taking the first two together: preservation of the rights of the parties and maintenance of the integrity of the judicial process. So, turning to practice then, ICLS has regularly ordered measures designed for these purposes. We can look at, for example, southern bluefin tuna, in which ICLS ordered the parties to refrain from conducting experimental fishing program without the agreement of the other parties. Land reclamation, for example, where ICLS ordered that Singapore not conduct its reclamation activities in a way that would cause irreparable damage to the rights of Malaysia. In Ghana, Côte d'Ivoire, that no new drilling in the contested area take place and no information from Ghana's activities be used to Côte d'Ivoire's detriment. And ICLS has also explicitly ordered that the parties do not do anything that would prejudice the decision on the merits. So I think on this point, I think we can safely say that ICLS takes seriously this goal of preserving the rights of the parties, maintaining the integrity of the judicial process, and has regularly ordered provisional measures to that effect. Turning then now to the non-aggravation of the dispute, I would suggest that this is more difficult to assess in terms of effectiveness, as it necessarily contains or requires us to think about counterfactuals, which are rather tricky. Nevertheless, if we look again at practice, we can see, for example, if we look at the Saiga case, that ICLS said any action or abstention by either party in order to avoid aggravation or extension of the dispute should not in any way be construed as a waiver of any of its claims or as an admission of the claims of the other party. And provisional measures have, in fact, on occasion contributed to the settlement of the dispute, such as in southern bluefin tuna, where even though the measures were subsequently revoked, in the year that they were in place, it was said by the parties to have been conducive to the settlement of the dispute. And similarly, if we look at land reclamation, where ICLS ordered as provisional measures, again, I think innovative and interesting here, an independent body of experts to be established. This body of experts that produced a report which was subsequently accepted by the parties and again led to the resolution of the dispute. And so, while perhaps more difficult to assess here, I think we can again say that ICLS takes the goal of ensuring the non-aggravation of the dispute, or even potentially the settlement of the dispute as seriously, and there are examples of ICLS ordering provisional measures to this effect in practice. Turning then to the fourth goal that I have given the ICLS to achieve, protection of the marine environment. Again, in practice, we have a number of cases to think about here. So again, southern bluefin tuna, here ICLS said the conservation of the living resources of the sea is an element in the protection and preservation of the marine environment. I think an important statement on the law here. And ICLS then went on to order provisional measures requiring parties to act with prudence and caution, wording that we'll see come up again and again, to ensure that effective conservation measures are taken to prevent serious harm to the stock of southern bluefin tuna. In Mock's plant, although ICLS didn't in the end prescribe provisional measures requested by Ireland due to a failure to prove urgency, it did prescribe different measures, urging the parties to show, again, prudence and caution, and to cooperate in exchanging information concerning risks or effects of the operations of the Mock's plant. In land reclamation, again, the ICLS mentioned prudence and caution and ordered the parties to establish the group of experts I've already mentioned. In the MV Louisa case, again, although ICLS didn't order provisional measures, since it accepted Spain's reassurances that it would protect the marine environment, it again, nevertheless, reminded the parties to act with prudence and caution to prevent serious harm to the marine environment. Finally, in Ghana, Côte d'Ivoire, the respondent state in this case requested provisional measures to order Ghana to halt the granting of further exploitation contracts over oil fields in the disputed area. And ICLS found that Côte d'Ivoire had not adduced sufficient evidence to prove the claim that Ghana's policies threatened the marine environment, but nevertheless found that new oil exploitation may harm the rights of Côte d'Ivoire and prescribed that Ghana should not allow any new drilling to take place in the disputed area. So what to make of this continued mention of prudence and caution? Well, former ICLS President Golitsyn has made a statement to the UN General Assembly that this equates to acting by taking a precautionary approach. I think, again, this is maybe tricky to assess in terms of effectiveness, but nevertheless, the tribunal has made some efforts to protect the marine environment, but it may in the future go further, I would suggest, and I'll come back to this point in the final part of my presentation. So look into the future then and how we might go about improving the effectiveness of provisional measures before ICLS. Here I would like to focus on this fourth goal that I attributed to the court, namely the protection of the marine environment. And I want to focus on this simply because I think that the wording of Article 291 really empowers ICLS to do more than merely preserve the rights of the parties. And this, I think, presents a particular opportunity for ICLS to do more and suggests that we could maybe see a shift in focus from a purely bilateral nature of provisional measures towards ICLS playing perhaps a more community-focused function. Alvarez, for example, has suggested that the wording of Article 291 allows ICLS to perform a governance function, requiring judges to consider the impact of their rulings on states, persons, or entities not directly represented before them. I think this is significant and really invites further reflection. And I think there is a challenge here as well for ICLS in these cases, in the context of preventing serious harm to the marine environment. This raises all sorts of questions of expert evidence, for example, on how we go about establishing what exactly serious harm may be. Now, ICLS may get a chance to consider this very issue sooner rather than later, depending on how events develop in practice. The example that I have in mind here, and the example that has been raised by a number of other commentators, relates to the discharge of treated water from the Fukushima Daiichi nuclear plant. So to maybe just give some brief facts on this, in April 2021, Japan published its basic policy to dispose of contaminated water from the damaged Fukushima Daiichi nuclear power plant. Its plan is to release 1.25 million tons of treated water beginning in 2023. This plan, which we should note is very much supported by the International Atomic Energy Agency, which has been conducting a multi-year review into the issue and working with Japan to enable it to treat the water to remove at least the vast majority of the radioactive chemicals from the water before it is released via pipeline from the coast into the sea. However, as you may imagine, Japan's proposals have been met with stiff opposition, in particular from neighbouring countries such as the Republic of Korea and China, and also by environmental activists. And former South Korean President Moon actually even went so far as to engage staff to look into the possibility of seeking provisional measures from ICLS to block the planned release. Perhaps this is an issue that we could come back to in the discussion to discuss further, because I think a number of very interesting procedural and legal and political issues are raised by the prospect of such a case being brought to ICLS. Just to give, in the couple of minutes that I have remaining, my own 2 cents on this, maybe we could think about whether the ICJ's bold approach in the recent Ukraine-Russia provisional measures might provide a blueprint for ICLS in tackling community issues such as the protection of the marine environment or climate change. Might that embolden ICLS to think beyond purely bilateral issues at play in particular cases towards playing more of the governance role mentioned by Alvarez? Of course, just to mention that the provisional measures ordered by the ICJ in Ukraine-Russia were really far-reaching, particularly compared to what had been requested by Ukraine. For example, including ordering Russia to suspend its military operations, in fact. And similarly, before the ICJ, there is a much lower bar for the link requirement to be met. Andreas Kulik has suggested that it's likely that we'll see an increase in requests for provisional measures in the next years as a result of the perceived success that Ukraine has had in requesting provisional measures from the ICJ, with more and more parties perhaps seeking to use provisional measures to obtain similarly far-reaching measures from the court. So I think that raises the question for us about whether ICLS could be tempted to lower the standard for the link test to less than the necessary at the moment, maybe bring it closer to the ICJ's sufficient connection. I think it's worth pondering, and I think it's worth discussing amongst ourselves and from this point onwards, but I would like to maybe finish on a note of caution with regard to what can potentially be achieved through provisional measures. They are, by their very nature, temporary. and they, of course, cannot prejudice any issue that is to be heard on the merits, such as jurisdiction, claims of the parties, and so on. And I think the statement of Judge Wolfram in Mox Plant is a good note of caution in that regard, namely that it should not be forgotten that provisional measures should not anticipate a judgment on the merits. This basic limitation on the prescription of provisional measures, emphasised by the ICJ, finds its justification in the exceptional nature of provisional measures. And in the context of UNCLOS, of course, we have to always bear in mind that the order of provisional measures depends on the willingness of states to bring proceedings before ICLS, given the absence of a power to make those orders proprio motu. I will stop there, I think, and leave the other issues open for discussion among the rest of you, and I thank you for your time.
Thank you, James, for your excellent presentation. Well, as you saw, Professor DEVANEY, he has walked us through all the relevant provisions of the ICLS on provisional measures. In doing so, he compared the relevant provisions of the ICLS with those of ICJ, and then he tried to assess success or otherwise effectiveness of these provisional measures by ICLS in the light of 4 goals or functions of provisional measures. And then he proceeded to propose some of the ways for enhancing the effectiveness of provisional measures of ICLS, focusing on the protection of the marine environment. And I'm sure that we'll have very interesting questions and comments later on.